So, Minister, look, I move amendment number 5 in my name, that where a person has previously been convicted of a sexual crime against the person or a person connected with that other person, so a relative, a family member of the person who has been the victim of a sexual crime, and where the perpetrator is on the sex offenders register for that previous time, that the term of the harassment order would run concurrent to the term that person has remaining on the sex offenders register. My concern is, Minister, as you know, the vast majority of these will come as orders before the courts. They will come in camera, and the practical reality is that the victim will be presented with a position that the perpetrator who is carrying out the harassment will agree to an order for 18 months or 2 years. Or we can go through the whole trauma of giving evidence and so forth, and the order may be applied for a longer period of time, but then the perpetrator will probably appeal that to the higher courts, and we'll go back through the whole process again. And the last thing that any victim wants is to be traumatised and re-traumatised and re-traumatised again. And in all honesty, what they will do is they will accept what's put in front of them. The perpetrator will agree to an 18-month or a 2-year order, and then we're back to square one again. They'll ignore that order, and the victim in the sexual offence, the person that has been traumatised by the harassment and has had to come before the courts prepared to give evidence, will have to do the exact same thing again. And they'll have to try and collate the evidence, get the witnesses, and they're being continually re-traumatised while this harassment is going on. And what I'm saying is that if someone has an order in place under the sex offenders register where they're supposed to comply with various provisions, be it for 5 years, be it for 10 years, or be it permanently, that if they come before the courts for harassment of the victim, where this post-release order has already been put in place, that the harassment order should run concurrent with that. So I do not want to see a situation where a sex offender who is released from prison has a 10-year post-release provision order put in place, has decided to harass the victim again of the original crime, re-traumatise that individual again. That individual gets enough energy and enough courage to actually gather all the evidence together to actually seek a harassment order. The very, very least that the court should do is to ensure that that harassment order runs concurrent to the sexual offender's post-release order that's already in place, rather than the victim having to negotiate on the corridors of the courts regarding how long the order will be put in place. And then when the perpetrator goes out again and ignores that order, the victim has to go back through the whole treadmill again. That's wrong, Minister. It shouldn't be left up to the victim to drive this forward. It should be the responsibility of the state to protect that individual who has come forward, who has given evidence, who has ensured that a conviction has been secured against this individual. If that individual, after they come out from prison, decides for any reason to harass that victim, then it should be automatic, absolutely automatic, that it would be applied to the full period of their post-release order, and that the harassment would be added on to that, and that we don't have a situation where they're back and forth, in and out of court, trying to have this enforced. That shouldn't happen. These people have already been abused. We have let them down. The system has let them down for one reason or another for that to happen in the first place. We shouldn't be providing a piece of legislation here that could potentially facilitate further traumatisation, further abuse of these victims. And I ask you, Minister, to really, really consider this particular amendment. Thank you.
Minister.
Well, thank Deputy Naughten for his amendment and the passion with which he spoke to the issue. I understand that the period in question in the amendment relates to the length of an order under section 10.4 in what has been referred to as the no contact order. As Deputy Naughten knows, where a person is convicted of an offence under the newly amended section, the court may make an order requiring the offender not to communicate with the victim or approach his or her place of residence, employment or education. Such conviction-based orders are distinct from those under Part 5 of the Bill. The latter are civil in nature and do not require any criminal proceedings to be taken. The conviction-based order may be imposed for such a period as the court specifies, and there is no maximum period for which an order may be imposed. Breach of such an order is a serious criminal offence and may be punished in the same way as the primary harassment or stalking offences would be. In other words, a maximum penalty of up to 10 years imprisonment applies. These orders, while primarily protective in purpose, are imposed in addition to or as an alternative to other punishments. This is distinct from the sex offender notification, which is not viewed by the courts as the imposition of a criminal penalty. In determining whether to impose an order and for how long, the court will necessarily need to consider multiple factors. While the existence of a sex offender notification requirement would clearly be relevant, other factors may also be relevant, and the precise requirements of such an order may differ depending on the circumstances. So I do not believe it would be appropriate to determine a minimum period with reference to sex offences notifications, because they are different and complementary processes. I would, however, note, and I think the Deputy does make an important point, whilst I differentiate between the civil and the criminal, and that is a factual differentiation, it is particularly important that the interaction between civil and criminal orders is effective, because this has to be about a victim's journey. So how they work and how they interlink is important. I do want to flag in the Dáil this evening that I do anticipate that further refinements may be made in the Seanad, and I'm particularly conscious of the importance of ensuring that all parties, including the local Gardaí, are aware of the making of an order. So whilst I'm not in a position to support the amendments for the reasons I've outlined, including the technical legal reasons, we obviously will tease through this further in the Seanad, and I've already indicated our likelihood to be back to the Dáil on other matters too.
With just 4 minutes remaining for this.
Minister, we clarify that you are indicating that you're likely to come back to the Dáil on this particular matter, on the bill in general, which you've already indicated. This is an issue that I flagged up at committee stage with the Minister for Justice, Minister McEntee. Minister McEntee did give an assurance to come back here, and having given full consideration to it. You know where I'm coming from in relation to this. I just do not want the victims to have to go through a second legal or a third legal system to be re-traumatised and re-traumatised again, and that we are effectively, in a perverse way, giving the offender some form of leverage in relation to this order, because if it's voluntarily, it can't be appealed. If it's not voluntarily and put in by the court, it's going to be appealed, and that places pressure on the victim. I believe undue pressure on the victim, and I'd like that to be taken out of the system, and that's why I'm asking you to genuinely look seriously at this particular aspect in the Seanad, and to come back to us here on it.
Thank you, Deputy Naughten. Minister, to conclude.
Well, I am indicating that we do intend to look at further how we can refine the civil and the criminal interactions as we're discussing here in the Seanad. I don't want to preempt those considerations, but that is what we're intending to do. What I do also want to say, though, is every single thing we're doing in this legislation, and every single thing we're doing in legislation we're bringing forward, and every single thing we're doing under the zero tolerance strategy for domestic, sexual and gender-based violence is about supporting the victim and the victim's journey. I suppose there are a number of ways of coming at that, and there's civil levers and there's criminal levers. So certainly, as I was trying to outline in my response to your amendment, we are looking at how we can support the victim in every way, and I would hate it to be interpreted or seen in any other way. But I do think that piece about how the civil and the criminal interact is a valid piece, an important piece, and we'll look further in Shannon and how we can refine it.
So I take it that the amendment has been withdrawn in light of the undertakings given by the Minister. Reluctantly withdrawn.